గుడ్ మార్నింగ్ వ్యూయర్స్, వెల్కమ్ టు కోనసీమ షార్ట్ హ్యాండ్ క్లాసెస్. మనం స్పీడ్ డిక్టేషన్ స్టార్ట్ చేసుకునే ముందు వచ్చినమాట, నేను షార్ట్ హ్యాండ్ క్లాసులే కాకుండా పర్సనాలిటీ డెవలప్మెంట్ అంటే వ్యక్తిత్వ వికాసం, దాని మీద అప్పుడప్పుడు నేను క్లాసులు చెప్తూ ఉంటాను. మరి ఈ వీడియో ఏదైతే స్పీడ్ చెప్పే ముందు ఒక హాఫ్ మినిట్ ఒక చిన్న విషయం చెప్తాను. ఎందుకంటే మీరు యంగ్ జనరేషన్, ఫ్యూచర్ అంతా మీదే. మీరు ఇవాళ ఒక సిస్టమేటిక్గా ఒక పద్ధతి ప్రకారంగా ఉంటే రేపు పొద్దున ఏదైనా సాధించవచ్చు, ఎంతైనా కూడా మీరు డెవలప్ అవడానికి ఆస్కారం ఉంది. అందుకోసం చిన్న సూచన లాంటిది మీకు ఇవ్వాలనుకుంటున్నా. ఇంతకుముందు వీడియోలో డిసిప్లిన్ గురించి చెప్పాను. ఇప్పుడు ఈ వీడియోలో గమ్యం, దట్ ఈస్ గోల్. ప్రతి ఒక్కరికి కూడా ఒక గోల్ అంటూ ఉండాలి లైఫ్లో. ఆ గోల్ లేకపోతే ఏమీ డెవలప్మెంట్ ఉండదు. సో గోల్ చాలా ఇంపార్టెంట్. ఆ గోల్ అన్నదానికి మీకు ఈజీగా అర్థం అవడం కోసం ఈ చిన్న ఎగ్జాంపుల్ చెప్తాను. విశాఖపట్నం బస్ స్టేషన్లో ఒక ఆయన విజయనగరం బస్సు ఎక్కడానికి నుంచుని ఉన్నాడు. నుంచుని ఉంటే అలాగ చూస్తూ ఉంటే అక్కడికి ఒక బస్సు వచ్చింది. ఎంత అందంగా ఉందంటే అంత అందంగా ఉంది. బాగుంది కదా అని చెప్పి ఎక్కి కూర్చునిపోయాడు. హాయిగా ఏసీ అది ఆస్వాదిస్తున్నాడు. బస్సు బయలుదేరిపోయింది. అది ఎక్కడికి వెళ్ళిపోయింది? కాకినాడ వెళ్ళిపోయింది. అది అంటే ఆయన వెళ్ళవలసినటువంటి గమ్యం ఏంటి? విజయనగరం అయితే ఆ గమ్యాన్ని దృష్టిలో పెట్టుకోకుండా వెళ్ళి బస్సులో కూర్చుంటే ఆ బస్సు ఎక్కడికి వెళ్ళి బస్సు? అది కాకినాడ వెళ్ళి బస్సు. సో మీరు గమ్యం వెళ్ళగలిగారా? వెళ్ళలేకపోయారు. మళ్ళీ అగైన్ కాకినాడ నుంచి మళ్ళీ విజయనగరం రావాల్సినటువంటి పరిస్థితి. అలాగే మన లైఫ్లో కూడా మనం ఏమి అవ్వాలనుకుంటున్నాం? ఒక డిస్ట్రిక్ట్ కలెక్టర్ అవ్వాలనుకుంటున్నామా? లేకపోతే ఒక ఐపీఎస్ ఆఫీసర్ అవ్వాలనుకుంటున్నామా? లేకపోతే ఒక స్టెనోగ్రాఫర్ అవ్వాలనుకుంటున్నామా? ఏ ఉద్యోగం ఒక పైలట్ అవ్వాలనుకుంటున్నామా? దేనికైనా సరే ఒక గోల్ అంటూ ఉండాలి. దాన్నే డ్రీమ్, ఒక కళ ఉండాలి. నేను ఇది అవ్వాలి అని చెప్పి ఆ కళని సాకారం చేసుకోవడం కోసం నువ్వు తుది వరకు కూడా కష్టపడాలా. అలాగే మీరు అందరూ కూడా అలా కష్టపడతారని, అలాగే ఈ షార్ట్ హ్యాండ్ కూడా చాలా బాగా నేర్చుకుని మంచి అభివృద్ధిలోకి వస్తారని మరి ఈ 2 మాటలు మీకు చెప్పడం జరిగింది. థ్యాంక్ యూ. Get ready. 5 seconds. Gentlemen of the jury, I will say to you on the subject of the evidence before going into the law in the case that it is for you to believe or disbelieve the various witnesses as to the facts. You must look at the witnesses. You must look at their opportunities for judging. You must look at the way in which they told their story, and you must consider whether they were really recollecting what occurred at the time or not, and you must likewise consider their interest. The plaintiff has a very material interest in this case. If he gets a verdict, it means so much money in his pocket, and interest very often colors our views when we come to give testimony. On the other side, you will likewise consider the interest of the driver of the cab, as he has been blamed for doing something, and it is for you to say whether it would be to his interest to shift the blame. As two numbers, as I have said to you in other cases where you have a larger number of witnesses against a smaller number of witnesses, you have the power, if you see fit, to believe the smaller number and dismiss the testimony of the larger number. But before doing that, you should give the matter careful consideration and not do so until you have found a satisfactory reason for dismissing the testimony of the larger number and accepting that of the smaller number. In other words, you must make up your mind in the case and see on which side the scales fall, not necessarily saying the truth lies on the side of the larger number. As I said, if you feel that the story of the smaller number is the true one, you have the power to dismiss that of the larger number. However, I leave that entirely to you. As to the medical testimony, it is of a different quality entirely. It is what is known as opinion testimony. Very often, medical testimony is of great aid in the case. Very often, it is of no assistance whatever. Where you have two sides in a case, you have doctors on both sides. If you have seven sides to a case, you would probably find doctors on all sides, and you would probably have different views from the doctors on each side. However, doctors are supposed to be men who are better able to judge of such matters than we are. You will have to give their testimony full consideration and make up your mind whether it will be of any assistance to you. If it will be of any assistance, you are to take the opinion of the doctors. You are not bound by the opinion of any doctor in the case. You are to consider their opinions for what you think they are worth and say which one is worth the most to you and which one the least, and say how they impressed you on the stand and make up your mind as to the weight you will give their testimony. As I have already mentioned, you have had a couple of doctors on one side and three doctors on the other. In some particulars, they agreed, and in others, they disagreed. You will consider their testimony and make up your mind as to where the truth lies as to the extent of the plaintiff's injuries. In considering the question of his injuries, you have a right to bring your knowledge of human nature into play, your common sense. You are not necessarily to be dazzled by large figures and the plaintiff's own story of the injury and the effect of the injury. It may strike you that it would be in accordance with human nature for a person claiming damages to put his side of the story of the injury as strongly as possible. Perhaps that is not a blamable thing because it is a natural thing to do. It may strike you that it is natural to do that. If you think that such a natural human instinct has played a part in this case and that Mr. Smith imagines he is very much worse hurt than he really is, or if you think there is any exaggeration of his injuries, you have the right to discount the extent of the exaggeration or imagination as you may, in the use of your good sense, think proper. However, it may be that it impresses you the other way, and you believe that the injuries are just as he detailed them. I leave that entirely to you. As to the accident, it is a clear question of fact. Did it occur as the plaintiff says it occurred, and as his numerous witnesses say it occurred, or did it occur as the drivers say it occurred? You must make up your mind as to that. If you believe it occurred as the plaintiff says it occurred, then you must make up your mind as to the extent of the damages. If you decide to give the plaintiff a verdict, if you think there was negligence on the part of the defendant's driver and that there was no negligence on the part of the plaintiff, it will be for you to say how much your verdict will be. In such an event, he is entitled to recover for his pain and suffering to start with. I cannot give you any exact standard as to that except to say that reasonable compensation is the standard you are to take based on the real facts as proven to exist. You have heard the plaintiff's description of his pain and suffering, and you have heard the doctor's testimony on each side. And if you find for the plaintiff, you are to make up your mind as to what the pain and suffering and injuries were and give him a verdict that you believe will be reasonable compensation. In addition to that, he would be entitled to recover for the actual expenses that he has been put to and which you think he will be put to due to the accident, medical expenditure, and otherwise directly attributable to the accident. He would also be entitled to recover any losses that he has been obliged to suffer in the way of extra help that he has been compelled to employ in his business.